Hello friends, hi. Hope you all are doing good. In this particular module, we are going to discuss the recent judgment of Mumbai Tribunal in the case of Renu Tharani, which was pronounced by the tribunal member Pramod Kumar. In this particular case, the taxpayer is a senior citizen who is a non-resident for the assessment year 6-7, that is for the relevant assessment year. The SSE shifted base to the United States just a year or two prior to the concerned assessment year, and in the income tax return, the SSE had only mentioned a nominal income of around 1.5 lakh rupees. The assessing officer thereafter was in receipt of several information pertaining to the bank's accounts which are held by several taxpayers outside India. The assessing officer could find that the assessee is beneficiary of a trust which is Tharani Family Trust, which has an investment in JW Investment Limited, which is a Cayman entity holding account in Switzerland. And the source of this information was the very famous Panama Leaks plus HSBC data leak, which was actually a case in which an employee of HSBC Swiss absconded, and he became a whistleblower to for that matter to provide several information of the taxpayers across globe. Around 1 lakh account holders of the Swiss were highlighted, which also includes around thousands of Indian taxpayers. The list was shared by the France authority to the Indian authorities. The Indian authorities had formed an SIT and initiated assessment proceedings. Several cases are currently in form of assessment or somewhere in the form in at an appellant level. So for this particular fact, he was a discretionary beneficiary of the Tharani Family Trust, and the account was not specifically in his name, but it was in the name of GW Investment Limited. And the account or the bank account had a total of around 196 crores equivalent in the United States dollars in its treasury. So considering this and the suspicion, the assessing officer informed the taxpayer of the information of the bank account details which he has, and initiated the reassessment proceedings. The assessee's contention was that in the United States, the global income of a taxpayer is taxable basis the citizenship. However, in India, the taxability of income is basis residential status. Since for the concerned assessment here, the assessee is a non-resident, there should not be any. He is not required to provide any information of the foreign bank accounts. He is not required to disclose his foreign income, and he stated that the income which could be of he first of all said that he is unaware of such bank accounts. Then he specified that when there is no requirement of requiring a non-resident assessee to disclose his bank account or income abroad, how can assessment be reopened on the ground that the taxpayer failed to disclose the foreign bank account? Further, the assessee also stated that there could not be any tax implication on him, cause income could only be taxable on receipt basis because he is a non-resident. So since the particular trust has not distributed any income, and he specifically is not owning any bank account, there could not be any reason for leaving any tax on this specified 196 crores ka sum. However, it is pertinent to understand that there are few negative points on this particular issue. Per bank records, the trust is terminated in 2015, just after this particular information is of the foreign bank's account is shared, and scrutiny and assessments and all sort of activities is initiated, and none of the assessee are deposited to the taxpayer. None of the assets are deposited to the taxpayer. So even after termination of the trust, we don't know where is it that the money has flown. So all such sort of information was not available to the assessing officer during the course of scrutiny assessment as well, plus during the course of appellant proceedings as well. The taxpayer did not provide bank account statements, or the source of deposits was not provided at all. She was saying that this could be the income which could be earned outside India, but she never provided a source of this income. There was no awareness of the settler and the source, despite the individual being the most senior citizen of all. So where did the money go on termination of the trust was also not provided. Further, there is a requirement of consent waiver. So because Switzerland is actually governed by the secrecy law, so if any financial authorities in Switzerland had to transfer any information to the tax authorities, they had to receive the consent waiver uh, on the secrecy. However, the SSE did not provide such sort of consent waiver. The reason for SSE was that since she is not owning bank account, she cannot provide such consent waiver. However, if you see from the assessing officer's point of view, there are enough and more reason for him to believe, not just suspect, that given that the SSA is not cooperative in nature in providing the information, there could be a reason that assessing is hiding something. How can it be that an individual is made a beneficiary of a trust just because, except where she is aware of the transaction? In more likely scenario, one would believe that being a senior most member of the trust, she is hiding some sort of information. The entire issue about what is the trust and how is the trust formed was kept discretionary and was not actually, steep details were not provided to the assessing officer or during the appellate proceedings. Pertinent to note that section 114 of the Indian Evidence Act 1872 says that the courts can presume existence of certain facts if person liable to produce evidence which could be and is not produced, which if produced would have been unfavorable to the person who withhold it. So given that such sort of sensitive information is not provided by the taxpayer, he actually has some sort of ill will. So in this particular judgment, the tribunal gave an interesting ruling. Though one would believe that for a non-resident, the income could only be taxable if it is received from India or if it is deemed to be received from India. Since there is no income in the bank account in India, this clause may not get triggered. Income which accrues or arise in India, or income which is deemed to accrue or arise in India. Since the relevant income source is not provided, one would believe that it may not be taxed in India. However, an SSE, how come by applying which sort of human probabilities could it be possible that SSE is earning income from outside India just within 2 years of her becoming resident of United States? It could obviously be some sort of Indian income which is hidden from the Indian tax authorities over the years. And more importantly so, where the SSE is amongst or and placed in the list of the person who is holding illicit account in the HSBC in the Switzerland. So while laying down the judgment, the tribunal had specifically had used some sort of beautiful language. Few things which remains pertinent to mention is that science has not yet invented any instrument to test the reliability of the evidence placed before the court or tribunal. Therefore, the court and tribunals have to judge the evidence before them by applying test of human probabilities. Human minds may differ as the reliability of the piece of evidence, but that's where the decision of the final fact-finding authority is made conclusive by law. During the specific observation which the tribunal also gave is that the decision cannot be an authority for proposition that wherever name of assessee figures in the base note from HSBC Bank Switzerland, an addition will be justified in each case. The mere fact of an account of HSBC Switzerland by itself cannot mean that monies in the account are unaccounted, illegitimate and illegal. The conduct of SSE, actual facts of each case, and the surrounding circumstances are to be examined on merits, and then one needs to consider the explanation of the SSE. There cannot be a shortcut and one size fit all approach to this exercise. So, though the judgment is not in favorable of a taxpayer, it would not itself mean that all the cases which are currently pertaining in assessment of the foreign bank account, or more specifically the Panama leaks or the HSBC leaks, could be considered as negative. I hope that you found this video useful. Do let me know if you have any comments and you want to dwell on this particular case law further. Thank you friends, have a great day.